Hello everyone. Today we're tackling a deceptively simple question. When does the Federal Circuit and Family Court actually have jurisdiction in a de facto matter? Because as many of us have seen, you can have a perfectly arguable case on the merits and still lose it all on the thresholds. Like whether a de facto relationship even existed, whether the requirements are met, and whether you're inside that 2-year limitation period. Under the Family Law Act, 4 questions govern jurisdiction. Number 1. Was there a de facto relationship? Section 4AA asks whether, having regard to all the circumstances, the couple were living together on a genuine domestic basis. That includes the duration, nature of the household, financial interdependence, social presentation, care of children, and so on. It's multifactorial, so no single factor rules the day. Number 2. Has a gateway been met under Section 90 SB? There are 4 options: at least 2 years together, a child of the relationship, substantial contributions and serious injustice if orders aren't made, or registration under state law. Number 3. Is there sufficient geographic connection? Section 90 SK requires that at least one party was ordinarily resident in a participating jurisdiction, either at the time of application or for a third of the relationship, or that substantial contributions were made there. And remember, Western Australia still sits outside this framework. And number 4, are you within time? You've got 2 years from separation to file. Out-of-time applications need leave under Section 44(5), and the court is increasingly strict about granting that leave. But once those gates are open, the court can alter property interests under Section 90 SM and make maintenance orders under Sections 90 SE or 90 SF using the familiar 4-step process, but with an explicit nod to how family violence can affect contributions. Let's look at what the full court has been saying lately. In Purevein and Mulfield, the full court upheld a finding that no de facto relationship existed despite affectionate messages, joint travel, and even IVF attendances. Why? Because the overall picture lacked common residence, financial interdependence, and a public reputation as a couple. The message is clear. Isolated couple-like acts don't outweigh the structural realities of a genuine relationship. Build your client's case so that all the signs of a relationship actually cohere. Similarly, in Chin and Bao, the court emphasized disciplined, factor-by-factor evidence. So things like leases, bank accounts, health records, and text messages, as opposed to sweeping assertions. It's clear from these 2 cases that you shouldn't rely on narrative alone, and if the existence of the relationship is in dispute, seek a separate Section 90 RD determination early, before you spend heavily on contributions evidence. In Waldman and Paddock, the full court reversed a grant of leave out of time. Ignorance of the limitation, or we were still negotiating, just won't cut it anymore. Applicants must show both a compelling explanation for delay and real hardship if leave is refused. On the other hand, respondents should press prejudice and the absence of hardship. Boyd and Logan shows a pragmatic approach once gateways are satisfied, focusing on fairness and proportionality at the interim stage. Even at that level, tie every submission back to the statutory framework. And don't forget Sophia and Tracy. In this case, the applicant failed to prove a de facto relationship at the time of conception, so Section 60H parentage couldn't apply. In assisted reproduction cases, the timing evidence can make or break parentage. At your initial meeting with your client, run a quick jurisdiction checklist. Ask your client, What are the start and end dates of their relationship? Were there any breaks in cohabitation? Which gateway applies under Section 90SB? Where were they living to address 90SK? And when does the 2-year limitation clock start ticking under Section 44.5? For evidence, annex a 1-page Section 4AA table mapping each factor to exhibits. Add reputation evidence from friends, colleagues, social media, and community activities. Prove residence with objective documents such as the electoral roll, licenses, and bills. And for parentage links, prove the relationship status at the critical date. For submissions, applicants, lead with your jurisdictional propositions. Cite evidence precisely. If you're late, open with the leave principles before the merits. Respondents, attack coherence. Show that the factors don't line up. Highlight the lack of co-residence or financial entanglement. And emphasize prejudice from the delay. A few quick reminders to finish. Don't just assume a 2-year relationship. Calculate it precisely, or prove another gateway. Don't skimp on reputation evidence. Photos alone are not enough. Plead your geography explicitly, residence periods and contribution locations. And always diarize that 2-year limitation early. If the relationship status is contested, consider an order like this. Pursuant to Section 90 ID, the question of the existence and periods of any de facto relationship between the parties be determined as a separate question before other steps. So if there's one thing to take away, prove your gateways early. Map Section 4AA to documents and treat out-of-time applications as uphill battles. The Federal Circuit and Family Court of Australia's current tone is clear. It's forensic about thresholds, and that's where de facto cases are won or lost.